Mr. Rathi spoke to the learned judge.
You don't know, take on the name.
I'm slightly worried. The learned judge has agreed, except.
You are the cause.
Yes, that's why I didn't want to speak.
Yes.
Except he says that his son is.
He is working with Mr. Manohar. So that should not be.
With his, Mr. Manohar's relative.
Mr. Naik, so they have, it's a common office.
So that's the only just to inform the bench of that.
No objections now.
We find that. The learned counsel for the parties agree that the dispute be referred to mediation. The parties also agree on the name of Honorable Mr. Justice Rohit Dev, retired as a mediator. We therefore refer the matter mediation of Honorable Justice Rohit Dev, the learned mediator. Determine the fees in consultation with the parties. Stand.
As an item 17, my lords were pleased to issue notice last month. This was an application for clarification which was dismissed by the Allahabad High Court. The limited clarification that I wanted was that the stay granted by the court on the first instance to enable mediation till the next date of hearing can't be extended for 2 years for the staying of the trial balance.
Yes.
Some request to mediation plans. This is a matrimonial matter. But it's 11, 12 cases where it's going on mediation of party, like no, please state that.
I can't object to that, my lords. My only request is, my lords may give a returnable date so that the same situation doesn't arise.
The Supreme Court Mediation Committee, the parties to appear before the learned mediator on 9 December through video conferencing. Able to do appear through video conferencing.
So great.
What about after 8 weeks?
So great.
Last occasion, the notices were issued on the appeal as well as the bail matter. But this appellant stands convicted under section 376D and sentenced to invulnerable imprisonment for 20 years. Now, so far as the evidence is concerned, there is only the evidence of TIP connecting the present appellant with the crime matter. Admittedly, apart from that, there is no seizure either of clothes or any seizure under section 27 matter which will be incriminating in nature. But the victim and her friend who allegedly accompanied her at the spot of incident has identified it. So far as that aspect of the matter is concerned, her friend admits during cross-examination that during investigation in the police station itself, all the accused were shown to him.
Where is that?
I not may come to
Page 119.
119.
He is the friend of the victim who was also on the spot. So the petitioner and one co-accused had got hold of the friend, and other two accused committed rape on the victim. Admittedly, he has not committed rape, but the trial court and high court finds that 376D. So because the petitioner and his friend is the co-accused got hold of the friend of the victim, the other two accused could commit rape on him.
How much was the sentence awarded by the trial judge?
20 years.
376D
Minimum is 20 years.
How did it go before the single judge?
Earlier, this was admitted by the division bench, but later on, the clarification was given that only the appeals in which life or death is there will be heard by the division bench, and therefore, at the time of final hearing, this went before the single judgment.
Because it's 20 years. It's more than
Life is normally 14 years.
Yes.
You argued the matter before the High Court.
Yes. On page number 127, rather 126, the bottom of it. Okay.
Yes.
This is petition number 3, the friend manner. Bottom of 126. It is not correct to say that after lodging the report by the victim for 4-5 times, I was called by the police, and during that time they reported statement of different type of statements. It is not correct to say that whoever were the persons, their faces were not seen. He volunteered that one person had covered his face. It is not correct to say that the person who had covered his face was not seen by me. Question: the person who had covered the face with the scarf, after how many days of the incident have you seen him? Answer: I had seen his face after 1 day in the police station. It is correct to say that the police had told me that those were the people who had covered the faces and are involved in the incident. Then again question: after how many after arrest, how many accused persons were shown to you? He says false. Now why the test scientific.
Next line also, right?
Yes, madam. It is correct to say that I had seen the accused persons in the police station, therefore I had identified them in the jail. Then he volunteers that he had seen the accused persons at the time of incident, therefore he identified them in jail.
Yes, Mr. Pandey.
Lordship may also read PW1 and 3 because trial court and high court both have said that PW1 and 3. PW1 is the victim because victim had identified all 4 of them. And trial court and high court holds that they were equally responsible. The other 2 accused who got hold of the PW3 were equally responsible for the offence. Lordship may page 108.
Where is the evidence?
108 is PW1 the victim. But if I just want to read PW1,
Here.
I know all the accused persons present today in the court. Out of 4 persons, 2 accused persons committed forceful rape on me. 2 accused persons caught hold of Akash, who is PW3, who is my friend. At this stage, the witness went near the dock where 4 persons are sitting. By showing a finger towards the 4 persons, she identified 2 accused who committed rape on her. Accordingly, both the accused, Shubham, age so and so, and the other accused is Ashok. They both committed rape on her. And in second para, the victim also identified the 2 persons who had caught hold of Akash, showing her fingers towards the accused. Accordingly, they made to stand on inquiring. One of them disclosed his name as Kunal. Kunal is the petitioner. So only Kunal has challenged the judgment. Kunal and Sandeep, they caught hold of the PW3. The incident took place on 14/6 near Old Vishnu Temple at Gantachuk between 2 to 2:30 p.m. On the day of I was going on Hero two-wheeler from Chandrapur to Mool with Akash. On the way we saw a board of Vishnu Temple, therefore we went to take darshan. After taking darshan, I and Akash were sitting beneath the tree talking. Three accused person came by foot there. They told us how we have come here and they are people from forest department. The witness identified 3 persons who came by foot, showing her finger by going towards the dog, showing, and so accordingly they made to stand. On inquiring, discloses name Shubham, Kunal and Ashok. So Shubham, Kunal he was already there with Shubham and Ashok. Then they demanded 1,000 rupees. Then they took phone of the victim and Akash, and they called the 4th person. As there was coverage in my mobile, therefore they made a call from mobile to 4th person. They told us boss is coming. They assaulted us with fists and blows. 4th person came there at that time. I felt like passing urine. Therefore, to pass urine, I went ahead. At that time, 2 persons came from behind and other 2 got hold of Akash. At this stage, the witness identified those persons who came from behind near the dog, showing finger towards them. Accordingly, they both made to stand inquiring. 1 person disclosed his name as Ashok and another is Shubham. Then they both told me, let us go intercourse or otherwise I'll kill you. Then I refused. Still, both of them committed. Then the next paragraph. So this regards to the other two accused who committed rape. In the middle of the page, the accused person who committed rape on me fled away. They fled away from there, and at that time, same two person who caught hold of Akash also fled away by leaving him saying boss has come. Thereafter, Akash called the forest officer saying, brother, come here. We narrated the incident to him. So after they saw a forest guard coming towards them, they fled. Had it been the case that forest guard would not have been there, the petitioner and the other co-accused who had got
Where is the medical
they might
report?
also
Where is the medical report?
Medical report of Akash has been annexed.
No, of the victim.
it's not
That is not appended.
Injuries are there.
yes, sir.
Mother, hymenal injuries there, other injuries which would signify that there are, because mother, since I was there before the law court, the other injuries which would signify that there was any forcible sexual.
No, it could be under threat. 4 persons were there.
Yes, mother. Now, mother, so far as that is concerned, mother, now, mother, it is nobody's case that either of the persons was armed or anything. Now, if on page number 132 MNC of Akash is seen, Akash says that he was hit on the foot, he hit on his leg with a stick, mother. However, there are no injuries. Apart from that, mother, even if the story of the victim is concerned, so far as she going to pass urine and two people following her is concerned, now, mother, that is not the story that Akash gives. Akash gives the story that she was dragged away. Dragging away is the story she gives in her own 164 hours. And mother, so far as PW number 3 is 161 and 164 are considered portions of proof, he says that two of the 4 persons had covered their faces. Now, who those people were has nowhere come on record. That portion has also been. And on top of that, he admits that the accused persons were shown to him in the police station. Mother, is what Panchanama is seen? The place where she was allegedly standing with her friend and talking to him, and the place where actually the rape took place are 200 meters away from each other in the deep forest. I pointed to spot Panchanama also. On page number 76.
Otherwise, they won't.
Yes, ma'am.
And Lordship, after the incident, the forest guard took the victim and PW3 to the nearby village. They went to a shopkeeper and they gave water to the victim. So the shopkeeper also identifies the accused person. Then PW3 and shopkeeper searched them in the village. They were not found. After that, forest guard and PW3 along with the victim went to police station. And the report was lodged immediately. Medical was also conducted on the same day.
Forest guard doesn't identify him. And the factum whether the incident.
How would the forest guard identify you? You had already left by that time.
Yes, madam. So that is, I was just clarifying that the Pantridewala did not identify us, madam. The question, madam, what I am trying to canvass before this honorable court is that, madam, whether the incident took place is not the question. Whether I had played the part. It is only the TIP that shows that I was there. Apart from that scientific evidence, so far as Shubham and Talandi are concerned, who were other accused, their DNA is there.
Your DNA is there.
Shubham and Talandi's
Your DNA matches.
Yes, DNA matches, madam. On the close of
DNA matches.
now the
Do
question.
you have any aspect taken out of 376T? Otherwise, you see, there's no choice for 20 years.
Madam, what I was trying to canvass, madam, so far as if the madam has just gone through the deposition of PW number 1, she says it was Ashok and Shubham who committed rape upon her. The story of the prosecution and the IO admits that in fact Ashok never committed rape upon her, mother. It was, according to her original story, it was Shubham and Sandeep. Ashok's DNA is not there, Ashok's was there, not sent to the CA because the IO admits it was never anybody's allegation that Ashok committed that. Now that version changes, she identifies Ashok in the top. Now to take it out of 376D, the question would come whether there was any meeting of minds, either before. As the story goes,
You read 376 D, you read.
yes, ma'am.
Read 376. Who is holding Akash? Between, they are holding Akash and the incident.
According to spot Panchanama, 200 meters, and take matters directly to that. On page number 77.
Mr. Aditya, with 376D, is common intention
34.
of each of the person to commit the offence of rape. Now, they are holding Akash 200 meters away.
She went for,
Correct, but they really don't know. It could be that they may molest her, they may, tease her.
because the accused, the petitioner and the other two accused call the other accused who went and they
If it
called
was
to
proximate or if they were holding the victim,
They were,
Whether those mobiles are seized from them.
yes, Your Lord,
From the other accused persons.
from the other accused person.
There was a mobile was snatched. They demanded, according to the prosecution, 10,000 rupees were demanded. They paid 2,000. And according to Akash, immediately one of the boys dragged the girl away. And according to the girl, she went for urination. One boy followed her and then the other boy followed her. Any prior meeting of mind between these boys is not there. Akash says that he was held. Now, why I was saying that he was not holding a weapon is this man. Akash and all these boys are similarly aged. Now, when the prosecution comes up with a story that two boys had forcibly apprehended him and were not allowing him to go behind his friend, now some injuries are expected. He says that he was hit on the foot, but then those injuries are not there. Any signs of struggle, perhaps our case wouldn't have been that way. But there are absolutely no signs of struggle. Again, I come to that. Whether I was part of those four people, the only thing that shows is the TIP and TIP.
Leave granted. Hearing expired.
Report.
Call for arraignment.
how long you have been there inside?
9.5 years already.
Wait for 1 or 2 more.
1 or 2 more years.
Great.
Jalta you conducted the trial also.
Unfortunately, not managed. I wished I did. Because so far as Kunal is concerned, there is no effective cross-examination. We are relying on the cross-examination conducted for the other accused persons.
The office bearer of association.
His cousin.
That's it, okay.
You know the names of all of them.
I some broadly. I was asking, are you an office bearer of the bar station? They said your cousin is the
That
office.
is my first cousin, man.
It rings a bell.
Yes, ma'am.
There is a direction to consider certain, this one aspect of considering the granting the regulation, this one the affiliation in terms of the 2009 regulation. Then thereafter there are a couple of other subsequent regulations, amendment to the regulations. Just I have to examine what is the effect of the subsequent change of the rule. Because it's a 2009 regulation has been applied and the direction has been issued very long ago.
An old matter, 12.
Very old matter.
Here the regulation from guidelines of 2000. Thereafter 2010 regulations came themselves. Now 2023.
So then that standing committee came and then
Correct.
Yes,
after one more, yeah.
yes.
Whether university is also now actually interested or not, I do not know.
May I submit those Millers? I am appearing for the respondent university Millers. Please, my lord.
Yes,
Yes, please, my lord. Millers, my offshore campus has subsequently been granted permission to run Millers. So my learned colleague will hand over the letter from UGC Millers. So there is nothing left from my side. This
That's
is-
what, if that is so, kindly record that matter can be discussed.
Yes, my learned colleague will hand over the document, Millers. Para 4 onwards.
Very good. The learned counsel for the respondent has placed on record the notification dated 1st of June 2021 issued by the Joint Secretary to Government of India, by which on the advice of the UGC, the central government has granted permission to the respondent number 1 university. Respondent number 1, that is SRM Institute and Science and Technology, into bracket with
Please.
deemed to be university, Chennai, to start an off-campus center at Irungalur, Tiruchirappalli. In that view of the matter, the petition is rendered infructuous. Dispose of as such.
Much obliged.
So 2014 का nothing would survive. None appears. By flux of time, none appears for. By flux of time, nothing remains for consideration in the presence. Dispose of as having rendered it purpose.
My lord, the respondent doctors committed grave offences.
Before
Why-
my learned friend starts,
My-
there is one
I'm
aspect.
at the privilege to
Just
talk about
let me,
the respondent doctors committed grave offences by intentionally giving false evidence on judicial proceeding, by collectively conspiring to suppress extremely fatal acute kidney injury, and 3 anti-coagulating injections have been pushed without any symptoms of thrombus, causing the death of the patient within imminent death. Subsequently, they also done D-dimer test, fraudulent activity, through which they want to prove falsely that thrombus is there and the patient died from that. All these evidences are already submitted before this honorable court, and the court can go through that can go easily look to the records and can get the, because these instances of perjury and fraud are contempts to the court. And this is a serious legal infraction that strikes at the very soul of the justice and sanctity of legal proceedings, and it would definitely hinder, hamper, or impede the flow of justice and prevent the court from performing their legal duty.
Stop it.
Should I go to the perjuries all the doctors have committed? They have already pushed 3 anticoagulant injections at this on the next day of admission, after 16 hours of admission, driving the patient to death, imminent death. It is almost a case of homicide. Then they have collectively tried to suppress that acute kidney injury happened. They have suppressed it. All through that they have suppressed it. They have issued the death certificate to one doctor who has not seen the patient at all. Without seeing the patient, he passed the death certificate against from the senior doctors, and he reportedly told that he came to the office on the date of the patient after 2 hours of the death of the patient, and all the doctors are telling that he was present. He was the last doctor who has actually treated the patient. It is a great incident of perjury. Then
I just point
Yes,
out
they have-
one aspect.
they have committed
One minute, Mr. Sir.
Yes. Yes, sir. I have already submitted.
One minute, please.
There were in this matter, there were 3 opinions because initially it was heard, the matter was heard by a 2-member bench, one consisting of the medical member, one consisting of the
Chairman.
administrative member. They differed in their opinion, and the matter was therefore referred before the Honorable President of the National Commission. And what my learned friend has
My
done.
objection
Yes,
is- my objection
yes,
is-
yes,
One minute, Mr. Sarkar.
It was not referred by the two division bench as per the rule to the 3rd member, to the president of, that is totally wrong and totally illegal and unjustified. That cannot be done as per the act of the CPA Act 1980. That was not referred to the president. President took about the case on his own. That was thoroughly illegal and that cannot be done. And whatever order he has passed is thoroughly illegal and unjustified.
Whether there was difference of opinion between 2 members or not,
They have not opened it, they have not expressed their opinion before that, the honorable president of NCD. And NCD, the president of NCD has taken up the case, has taken up on his own, without making any reference by the division bench. And as per the CPA Act, they shall make a reference to the president of NCD. That was not done. And after that, president of NCDS has passed the order, that is totally 40 to 60% of the order is copied word for word from the medical member of the NCDS. And actually,
What has
15
happened is,
expert
Lordship, now
specialist doctors.
what Mr. Sarkar has done, the appellant has done, he has only challenged the opinion of the Honorable President. There is, after the opinion of the Honorable President was delivered, the final order of dismissal of complaint was made on 12th of March 2021. That has not been challenged.
Consequential.
My lord,
No, but the other 2 opinions are also not challenged.
that is the wrong.
He
thing has
only
been-
challenges the opinion of the Honorable President in this appeal.
That is the wrong thing has been telling. In the SNP, the apex court, the honorable court has told that you have to only challenge the 3rd order of the president. And the first 2 orders have been cancelling each other because that is a split order. That is the order of the Supreme Court. That is the order already there. And as per that order, I have to challenge the 3rd order. And accordingly, I have challenged the 3rd order. The first 2 orders doesn't exist at all. They are cancelling each other because in the SLP, the honorable judge of the apex court, sir, you are also there, sir, in the bench, and it was decided that that is a split order, and these 2 first orders are cancelling each other.
Lordship, I have my counter affidavit of respondent number 1, page 207 for a moment.
(207).
Page 207 of counter affidavit of respondent number 1. Lordship, this is the case issued by the National Commission whereby after the split opinion of the two members, a notice was issued that the matter will be placed before the Honorable President, and also the issue on which it will be placed, it was specifically mentioned. And thereafter it contained, just Mr. Sarkar, just hold on. And thereafter the opinions of the two members have been given. The Honorable President concurred with the opinion given by the medical member. The Honorable member himself was a qualified doctor who had delivered this judgment dismissing the complaint. Now, he also had the occasion to go through all the medical records, and we had also filed separate MRI plates, USG plates, around 35 plates were filed, which the Honorable member had himself perused and seen it before delivering the judgment. I just wanted to point out that Lordship may just have page
My lord, I have got,
66 of my counter.
my lord, I have got one submission. 15 expert specialist doctors or medical council of India, now NMC, National Medical Commission. They are experts for the last 40 years experience in the hospitals, large government hospitals. They have come out, NMC, National Medical Commission, West Bengal Health Department, as well as West Bengal Medical Council. They have categorically stated the 6 doctors have committed grave injuries, medical negligence. And medical negligence.
We'll hear it, yes. Admit hearing expedited.
Sir,
The original records will-
that the proper investigation should be investigated, and that should be investigated under section 195 IPC. They have committed grave fraud, perjury,
Will
and grave
consider-
offences.
Yes, thank you.
The original records may be called for,
Call-
because
call-
that would be necessary.
Call for RNP.
Item 22.
इसमें मैंने
My lords, in item 22, despite execution of lease deed, conveyance deed, my lords, respondents they have handed back the possession of land to previous landowners. My lords, I will point out certain orders which will make the position clear. My lords.
My lord, at the outset, may I submit, my lord, before my learned colleague begins? There are two facts, my lord. A, we categorically denied, we have not handed it over, and we have stated it on affidavit. The other aspect is, my lord, they have filed 2 petitions before the Honorable High Court. They are still pending, my lord, with the prayer that the possession is not being handed, that it is being encroached with by somebody else. My lord, we have
My lord,
placed those
we are
orders
here.
also, my lord. I appear in 22.
My lords, I am in contempt as the previous land, they have handed back the possession, and now the allottee, the original allottee, they have not got back their lands. My lord, therefore we are in contempt.
This is 1638588 of 2012. I am the petitioner in person in that.
My lords, at page 117.
And I have placed the photograph of the property where the banquet hall is being run. This is the last Sunday photograph, sir. Please. Please give it to.
Like this will
My
not be
lords,
able to
at
take
page-
instructions over the
At
photographs.
page 117,
This is
Relevant.
this is the Google map, my lord.
Please
the-
allow me to submit, then you can.
This is the Google map of the location. Please.
My lords, at page 117, the relevant page at 123, last para. Since the main SLP in hand pertain to allotment of residential plots to the petitioners who have been waiting for same since the year 1981 onwards. Direction is required to be issued even to DDA, that in case the applicants succeed in their claim under section 24 of 2013 Act, the DDA shall not hand over possession of acquired land to petitioner. Applicants but would pay compensation to them afresh in accordance with provisions of 2013 Act. So, my lord, this is the order, and at page 152. This is the relevant. And the other is page 152 at 155.
Who are you?
My lords, the allottees who have been allotted as per the this scheme which has been promulgated in this scheme, after allotment, we have been allotted the plot, lease deed and conveyance deed have been executed in our favor. We have been given possession also on paper. But when we went back on our plots, my lords, as per our deed, and 162, my lords, at 162, 163, they have handed back the possession of land, previous landowners, where they are carrying out demarcation. My lords, once the land has been handed back to the landowners, to the subsequent allotee, how a demarcation can be done subsequently. And in their counter affidavit, they have admitted that in case they have handed back, they will they'll try to take back the possession. Why they have made this statement in their counter affidavit? My lords, a clear statement is made. My lords, may kindly have page 10 of their counter, which clarifies that they are admitting that it has been handed back. The land has been handed back. My lords, in their counter they state DDA will evict the present occupant from land under reference, or else DDA is ready to consider for allotment of alternative plot to petitioners. They are even ready to give us alternative plot. Even though we have been allotted the plots, we have grown our all the entire payment expenses we have given. Now they'll give us the alternative plots. How can they bear? My lords, they are at the age of 80, nearing 80. The petitioners. Petitioner number 1 is nearing 80 and 2 is on bed. Now they want that before they should go back, at least they should get back their land.
Yes, have you given back the land to the,
We have stated so very categorically in our affidavit that it is not being given back, my lord.
1 minute now, please.
Because para is
And have you handed over the possession to them?
My lord, the difficulty is, my lord, that Rohini residential scheme in Rahul Gupta, my lord, it was given, my lord, post these orders. My lord, now there is a restraint. They have also challenged it in parallel proceedings where there is a lapse of acquisition, my lord. Multifarious litigations have been filed by them, my lord. We have stated so in the order, my lord. If my lords may see the counter affidavit that we have filed, my lord.
1 minute.
Please, my lord. DDA.
I read out the affidavit submitted by the.
Permitted to have a copy of that at least.
There's a detailed order of justice came there of 58 January 16.
Complete.
My lord, para 9, my lord, of my affidavit. My lord, here they want possession for which they have parallelly filed proceedings and are pending, still pending before the Honorable High Court. My lord, Rahul Gupta, this apex court had made it very clear that when it came to interim directions, only then they were to knock the apex court, my lord. I'll read it all, my lord. Para 9 of my petition, para 9 of my affidavit. That while disposing the main petition with order 10-350, this honorable court was pleased to observe that no court shall entertain any application for grant of interim directives, and therefore directed that the same be delegated to the same court. At the same time, the honorable court was conscious enough that developing issues may require proper adjudication, and or directed that all alike issues which may arise in connection with the above mentioned allotment of plots, it shall be open to the allottees to approach Honorable Court of Competent Jurisdiction. In view of the matter, the contempt petition is not maintainable. My lord, I move on to highlight the orders, my lord. They move the Honorable High Court with WPC 73179 of 22 and 3198 of 22, wherein notice was issued. The present contempt has been filed subsequently. My lord, strangely, I'll take my lords through the orders, my lord, the two orders, my lord, I've annexed in the reply. My lord, it was made aware to them that the apex court, the matter is pending there at the stage, my lord. Yet they choose not to indulge out here any fact for the two matters pending before the High Court. My lord, they are still pending for the allotment and possession. My lords have it, my lord, I've placed it as an annexure. My lord, R11 at page 12 of my counter, my lord, if my lord has it. So, my lord, there is no contempt at all. My lord, Farrell, page 12.
Have you handed over the possession of the land to the original landowners or not? Where is your denial to that?
Manoj, in their affidavit,
14, my lord, page 14. Para 14, page 8. My lord, so, another paragraph prior to that, my lord. My lord, para 11, I'm sorry. Para 11, page 5 of my counter. Para 11, my lord's got. Para 11. My lord, I'll read it for my lord's convenience. The main contention of the petitioner is that plots allotted to them, which they were handed over the possession, have been returned back to the original owners on 12/7/16. It respectfully submitted that LM department had only participated in the demarcation process along with the revenue staff of GNCTD and never handed over to its previous owners. On perusal of the proceedings also, my lord, and annexure P21, which they have annexed, my lord, it reads demarcation proceedings, which they are reading as possession proceedings. It is not possession proceedings at all. The possession is not with the original landowners.
my lords, in their counter, only please have page 10. In their counter only, page 10. Page 10 at the top. However, my lords, however, DDA will evict the present occupant from the land under reference, or else DDA is ready to consider for allotment of alternative plots to the petitioners and other affected persons to whom the plots under RRS 1981 is allotted in the above mentioned khasra numbers to some other place under the scheme. They themselves are making this statement.
Illegally encroaching over the land, not that we have handed over the possession, my lord. It is Rohini residential, my lord, where my lords, this apex court had held very categorically that the possession will be deemed with DDA. Rehearse the fact whether anybody occupies or not. My lord, and despite of that, my lord, just the prior paragraph, my lord.
My lords, once possession is handed over,
My lord, that's what we are stating, my lord. They have parallel proceedings. Even in High Court, they have the matters are still proceeding where they have alleged that few lands are allegedly encroached by few people. So they are parallel proceedings, my lord.
my lord, High
It's
Court
not
is
that-
not relevant.
My-
We withdraw it.
My lord,
Those landowners,
because these matters are proceeding at so many places, my lord. For this, my lord, we had stated as early as in this counter that we would be removing. But it's not that there's any contempt of court that is happening, that we have handed over discreetly to anybody, or that we have handed over possession to anybody, my lord, nothing at all. This Rohini residential scheme, Rahul Gupta, my lord, had made it very clear. The DD will have deep possession, my lord. The encroachment is rampant there. And my lord, parallel proceedings for the same encroachment in Mahinder Dhaiya, my lord, that I have annexed. They are still pending. The matter is coming up on 19th February.
she says that she will withdraw it.
My lord, she makes this. My lord, I humbly wish to question myself two aspects, my lord. When in Rahul Gupta, it is categorically averred and made clear that it will only be for the interim injunction that will trouble this apex court, my lord. For the possession and the normal allotments of Rohini residential, it will be with the competent High Court, my lord. My lord, I leave it to my lords, my lord, with this, that we have categorically stated that Rahul Gupta had made it very clear that people need to knock this apex court, my lord, and trouble this honorable apex court only when there's an interim injunction needed. My lord, not that for every allotment for the Rohini residential they need to come here, my lord.
My lord,
So the two matters are pending, my lord, and it was there in the order, my lord, that I was taking my lord's to when my lord had put that query not handing over the said fact to the private owners, my lord, private landowners. I was taking my lords to the orders where it was held and it was opined, my lord, it was made clear that these matters are also pending here. They do not whisper a word, my lord, when they file this contempt proceedings in 22. They do not whisper a word about it, my lord, in the entire pleadings about the matters pending, two matters pending at High Court.
my lord, this allotment was done under the supervision of this honorable court. So, my lord, there is a specific direction also that in case there is violation, we can approach this honorable court. So, therefore, my lord, we are in contempt. Since we have not received our land, allotment letters were issued in 2014. We are in 2024, my lord. These deed is also executed. Since then also we are not getting back. Please deed, conveyance deed, everything is there. Possession letters we have been issued, but we have not got back our land.
My lord, it is
That is why we are contempt. And my lord, off the record, there are 40 plots like this. I am for only 4 plots. But the dispute which is going on, it is with 40 plots, the same possession they are having.
Yes, Mr. Gupta.
I'm now in 168, 598. I'm taking care of this particular issue since 2009 in High Court. High Court also categorically rejected TDS plea.
Justice Shukla was appointed as a commissioner.
Yes.
Same matter.
In 2000,
Who is appealing?
let us carry the 386 created. In 2012, when this honorable court issued the direction, it was very clear that we made very clear to the honorable court that no litigation on the land is pending which is being for allotment as well as for the development of Rohini residential scheme. Now, to the best of my knowledge, and I have already mentioned in my subsequent applications and appeal, that the land dispute was very well pending on this particular land which has been raised by the present petitioners. They categorically and illegally rejected my submissions that there is no land litigation pending on the land which is being used or being developed or being allotted for the Rohini residential scheme. Subsequently, this honorable court in 2016 rejected various claims of the area makers. To the order passed on 18th of January 2016 and subsequent order 28th of October 2016. It was all mentioned very clearly that if there is any dispute or any litigation pending, then those litigations should be brought to the notice of the honorable court only. DGA did not mention that. And these 40 plots, I raised the issue in my review petition as well as in contempt petition that was filed by me that this is the disputed plot, this is the disputed area. But they did not make any submission on that issue at all. Now, one more issue I would like to mention again in coming IA, that the plot allotted in 2005 and 7 prior to my entering into this particular dispute were also disputed. I filed the rate in 2009, but the plot allotted in 2005 and 2007 are also disputed, and almost 700 plots are handed over to the plot allottees so far. They have taken the money. On paper, they have given the possession also, but the plots are not with the DDA at all. In one of the land litigation case, I have filed the intervention application. In Shamsar Agarwal case,
no court, other than this court.
My lords, at page 162.
My lord, the matters
Now,
where the Honorable High
I would-
Court
I
has
would
seized
like
of the
to-
petition, my lord. My lord, the Honorable High Court, my lord, the two petitions, my lord, at page 19 is another writ that they have filed for the same customers, the same prayers, my lord. If, my lord, my lord,
saying that any application has to come here.
Yes.
my lord, my lord, my lord, it categorically states that when it comes to interim prayers, my lord, that is what I was reading, my lords, through that paragraph in my affidavit. For any interim prayer, we should not this court, but for the allotment of plots or the cancellation or any allied issues, my lord, the competent high court should be known. So, my lord, here they are doing, my lord, all the allotments, they are going to the high court, also parallel proceedings out here, my lord. My lord, for example, this particular, my lord,
My
this
lord, these are
particular,
the photocopies of the noting side of the same case file. DDA official is recommending to use Rahul Gupta's order to the DDA fellow officials.
so, my lord, these notings, my lords, are
In
very
the
well
same
aware.
case file, not a general file.
My lords,
And this is the photograph which I have taken last Sunday of the same the plot, where a working banquet form is being run by the encroacher, and DDA is silent. This is the Google photograph. Google photograph taken the PDF of it, and I have submitted. I'm submitting this, and I have already submitted this through mail in my the intervention application and the additional rejoinder.
My lord, I'm not appearing in 22.2.
Who is appearing?
My lord, I'm appearing in 22 and
Who is appearing? Is it listed today or not?
it is listed. We have no instructions, my lord. For those two applications, we don't have any.
But I'm talking of 22 at the moment. Talking of 22 at the moment. And this is the notice side of the same case file. That is collected under RBI Act on the DDA NM department. It clearly says, in view of the facts stated above and fact that the similar SLPs have also been dismissed by the Honorable Supreme Court, the department may please examine the case administratively to decide the further course of action, keeping in view the requirement and ground position at site and also the direction of the Honorable Supreme Court in Rahul Gupta case. I have already submitted to this Honorable Court through my additional rejoinder affidavit as well as the affidavit. The rejoinder affidavit is a blatant lie. Completely. There is nothing else in that.
my lord, DDA is hiding something in this case, it appears. So, my lord, there is an order passed by this court on 10th feet 15 at page 55. The relevant portion by this content has been filed, my lords, at page 55. In bit from middle it starts
10-3-15.
at page 55.
The orders were passed post this also, my lord, where for the residential scheme, where it is made very clear that DTA is in deemed possession and anybody else has a rank encroacher. At this.
But if he is a rank encroacher, what is DDA doing?
Parallel proceedings for acquisition of land also.
Acquisition, where acquisition that is concluded by Justice Care's order. That 1 minute, please. It is concluded by Justice Care's order that even if they succeed, they will be entitled only to enhanced compensation under the 2014 Act and not for possession. So the possession of the plots has to be handed over to them.
which is 19th February. For the same land, for the same position, petition is pending there also, madam. Action R119, man, at page 19, we are done. I will be ordered page 12 of my counter that I'm stating my lords. I my lord, page 14.
Madam, they can be directed to remove the encroachment.
Very well, madam, we have stated it, madam. If my lord made it, madam, we have stated it on
And they should do it.
madam, at the same time, the possession, the proceedings in the High Court for the same land, madam, which you have annexed, that should be.
We will withdraw proceedings with
The
the High Court.
statement should be made here, madam. Madam, if my lords may deem it, we'll have it there over here, madam.
Madam, that is.
No, the fact is that cancellation on of the allotments, madam.
Cancellation of? Cancellation of?
Of the plots of 22.2, madam, that is regarding cancellation of plot in any residential scheme. This is for allotment and possession, madam. These are to be done by the my lord. We do not, madam, I'm here to state, madam, that this contempt as of now, madam.
No, madam, we are.
We have done, madam, if this is an encroachment, we are willing to remove the encroachment, but I'm.
What are you doing from 2016? If you are willing to remove the encroachment? There doesn't appear to be a sincere will or desire to do it.
And it's not that there is a non-conscious desire, madam. We have been taking possession of part of tax, madam, utilizing them also, madam. It is a scheme that is not yet ended as of now, madam. Madam, and here we are stating how, madam, at page 19, we have taken.
Is there a list of litigation? Situation appears to be, you have acquired, according to you, possession taken,
I'm happy to work with them, as per them also.
they are the allottees.
And possession also has.
Correct, but they say that no, there are encroachers there. In the meantime, the owners from whom you acquired have gone to the High Court. Is there any petition by them saying lapse and restore the? No. Is there a petition by them in the High Court? By these people for allotment?
Possession.
Close it off. Keep this in 2 months. In your counter.
I've stated that in the affidavit, I will to the order where it is stated that the matters are pending. Again,
There's no urgently you must. Where is the counter?
Inquiry as to why.
I have stated about the action that I have annexed. Counter at page.
It is in Mahindra Singh.
Again, 22.
Counter 1 minute, Miss Kripal. Page.
Page 3 and I begin with the details of the affidavits.
Yes. Yes. Yes.
And therefore, elected that CB functions about that certain issues of delegation. I have completed on which means that the above mentioned lot it shall be open to the allotment. And petitioner also.
Or petitioner.
And has moved WPC 317.
Now, what is the relief claim there?
Clear possession be handed over because there is an encroachment by one.
Who are all parties? DDA is a party.
Party, madam, the orders will make it clear. Madam, just my lord, for half a minute. I'll read this paragraph and take my lord through the orders there, madam. It says WPC where the notice was issued. That Subsequently, on 20th April 20, the petitioners have deliberately concealed this fact. My lord, not a whisper about the two matters filed, my lord. And my lord said that petitions are now listed for 19th February 25, my lord. The pleadings are complete in that matter, those matters also. My lord, it says 12 January 23. They are now listed for 12 January. Now that they are listed on 19th February 25. Now you can, my lord,
Expect to dispose, I shall to dispose of this petition.
And what about Mr. Rahul Gupta?
Mr. Ram,
Yes, that you are not appearing, you are saying.
in appeal, I mean 22.2, my lord, that is the cancellation of plot made to them because it was earlier Rohini residential scheme. Now the DD is in disposition, my lord, we have cancelled the
But
allotment.
22.1 is also Rahul Gupta.
Yes.
2 is also Rahul Gupta.
Intervening applications, my lord, in other matters, not here because of this, my lord, liberty granted that in cases where they needed interim direction, they could get here.
Is Mr. Rahul Gupta a party in 3179 and 3198? Are you a party, Mr. Gupta? In writ petition 3179 of 22,
My lord,
in the High Court, and 3198.
actually, Rahul Gupta, what has happened? All these Rahul Gupta, basically there are other matters in Rahul Gupta. They filed an intervention of application. For example, he was mentioning Saraswati and Shami Devi or something he was mentioning. Rahul Gupta. In the matter of Rahul Gupta, in the matter of Shami Devi, and then they bring taking liberty of this liberty granted that they could talk
He's
in
making a wrong statement. Completely wrong statement.
Madam, may I submit them? My friend will have.
I-
So these three annexures that I was taking my notes to, madam, these are the petitions that are being filed by them in Mahinder Singh for the same Rohini residential scheme and the plot. And as far as 22.2 goes, my lord, in that Rahul Gupta is coming here against cancellation of a plot. So, my lord, I humbly submit, my lord, a cancellation of a plot, my lord. My lord, maybe entertained in High Court, my lord, that this effect no troubling my lords for a cancellation of plot in Rohini residential. My lord, because the honorable, this apex court was very clear that when it came to cancellation or allotment, the honorable High Court would have dealt, the court of competent jurisdiction. It was only when it came to intent protection that this apex court would have had to be troubled. My lord, so this annexure R1, R2 and R3, my lord, that I placed on record. My lord, annexure R1 and 3 at page 12 of my counter. My lord, so, my lord, the 3179 it says the petitioner says that it was allotted a plot, issued a possession slip. However, one Bhupender Singh is not possessed. He has possibly been given possession by DD. So again, for that, he comes here. So the next order, my lord, if my lord's may.
No, you read the para for intimation from the deputy director.
From that plot number before. Mention of this was given by not issuance of possession. The possession of plot has been issued by office. It seems that the possession is not as they did.
What does it mean that you are writing in your department that possession has been wrongly given?
Because of the orders in Rahul Gupta manner, which says that DD will be in deemed possession and any other possession will not be given. So, my lord, post that, my lord, if I don't see the same. My lord, then would come to this. With the petitioner being involved in this and after litigation. Therefore, possession of the same one not to be given. For some reason, they are given the possession. Then the DD ought to rectify the situation. So, the same reserve. My lord, the next order in my lord, Miss Harish Chandra, my lord. That is also for Sector 28, Rohini, for issuance of possession slip. So, my lord, the honorable is seized of the matter. Then, my lord, at page 18, my lord, both the matters, my lord. DDA takes time. sorry, Madam, page 19, I read for that one. Learning counsel are responding DD that on the same cause of action, the petitioner has also filed a petition alleging contempt before the Supreme Court. He states that the petitioner must elect one proceedings and he cannot.
But they say both are different, they say, just in the next paragraph.
See, that is what they claim, but I was just.
Can do one thing. 42. Right.
Before High Court, my prayer was direct an inquiry to be conducted as by possession of fraud various numbers has not been handed over to petitioner for conducting an inquiry. Here, please.
Sorry, the contempt petition.
Sir, my intervention.
1 minute, please. 22
Please
minutes.
be, allowed in this particular case.
Contempt petition. Mahendra Singh Dharia has also filed a writ petition, being writ petition number 3179 of 2022 before the Delhi High Court. Paragraph. A grievance that is raised in the said writ petition is that though he was allotted plot number 350, bucket 3A, sector 28, Rohini.
A3, sir. This is A3.
Here it is written as 3A. The one Shri Bhupender Singh is in possession. We find that it will be appropriate that the present contempt petition is kept pending. And
My lords, I am appearing in 22.2. It is a
let us pass.
It's a different issue, your lordship. Just
So let us permit us to pass our order in at least one matter. It will be appropriate that pending and the High Court is requested to decide the said petition expeditiously.
My intervention application in this particular case and rejoinder affidavit and additional rejoinder affidavit should be accepted, sir.
1 minute,
Please.
we therefore direct the contempt petition be posted after 6 months. In the meantime, the High Court is requested to decide the writ petition number 3179 of 2022.
And one more is there.
Coming up to 19 February, right?
And 3-2. What is the second petition?
3198 and 3179.
That is filed by that Harish Chandra is not before the court.
But allied petition. Same, he is also saying.
At 3197 and 3198 kar dena. Now, which is the other matter?
Sir, my intervention should be allowed in this particular case.
So then our intervention.
We taken up later.
We'll consider it at that point of time.
No, please, because I filed the additional the rejoinder.
So we'll consider it when you hear this contempt petition.
Contempt is pending, kept pending here.
We are not disposing of the contempt petition.
No, because I have to submit so many other things.
So we'll hear you at that point of time.
This particular issue, sir.
Yes.
The matter is 70.
We'll hear you at that point of time. We are not disposing of your intervention application. We can point out those documents at that point of time.
Because the problem is that if I have to file something, then I am not allowed to file the additional affidavit or. No, please. Because I have to file this or these photographs of just about 10 days back in this particular case. That what is the latest?
See, all that may not be subject matter here. She is right. Any interim orders, the court said you are now making this proceeding, by filing contempt, expanding the scope.
In Rahul Gupta's case, 16385, the land litigation is already there. It has to be. Land litigation pending.
In Rahul Gupta's case, the issue was basically with regard to non-development of the facilities.
It was also like on the issue of the litigation of the land.
Allotment and also not providing the necessary infrastructure. So therefore, I think Justice Shukla was appointed as a court commissioner.
Shukla was appointed just to.
Justice Shukla.
Sorry, Justice Shukla ji, the VK Shukla was appointed to see whether the development has taken place or not and submit the report. It was not on the issue of allotment. It was on the issue of the development.
So that is what I was saying, but she's saying that there was also an issue with regard to allotment. As I recollect, we'll have it after 6 months. Yes. What about you, your matter?
No, sir, 72510, the 22.1. I have filed the application for direction. And this direction is, as she said, that there are so many litigations pending. There are 4 cases already pending in this particular court, this honorable court, concerning to the land litigation of the Roni residential scheme. And there are so many other cases. Now, in these cases, they have not used the orders passed in Rahul Gupta's case, but in so many other cases, they have already passed.
So where is the prayer in this?
Page 62.
In 4 such cases, those are pending and one has already been disposed of. They have already admitted that the land litigation of this particular village is already covered through the Rahul Gupta's order.
How can all these issues be reopened in a dispose of petition?
No, sir, they are raising the issue in different courts of this honorable court. They are raising the issues. I have not raised the issue. As I said earlier, the sector 30 pocket A2 was allotted in 2005 and 2007.
Court disputes also.
How can we direct all these proceedings to be brought in a dispose of petition?
Sir, as per the direction, the land litigation cases were to be brought in the case of Rahul Gupta.
To be considered along with the contempt petition. Yes.
Here is a case where the allotment has been cancelled because they failed to make the payment. I got changed it in the name of the bike and then after changed.
22.2.
At the outset,
Let her know that.
Your Lordship, at the, may I now please? Your Lordship, at the outset, it's an innocuous application. The land was allotted to my late husband who died in 2021, Your Lordship, for January 2021. And I have also attached my death certificate and everything. Last date, as per them, to pay the premium was 31st December 2019, which is as good as 2020. 1 year, Your Lordship, my husband was, we were going from hospital to hospital. He was suffering from a health disease. Eventually, he died. And thereafter, I have not been able to just pay my premium, Your Lordship. That is the only grievance I have, and I should be allowed that time, Your Lordship.
But how can we do all this in a dispose of SLP?
The land was allotted in furtherance of the 2015 order of this honorable court, and therefore we filed this IA in this SLP 16385/2012.
You file a writ petition against the cancellation, will protect the time for latches.
Your Lordship, I just need 1 month. If they can provide us some time, I will be able to pay the amount, Your Lordship. Your Lordship, if you look at the timeline, the last date for payment and deposit was 31st December 2019. Shortly after my husband, who's now dead, Your Lordship, we've been he was suffering and we somehow could not deposit the said amount. On 5th January 2021, he died, and thereafter we have been pursuing this. Your Lordship, in 23, they have allotted a similar plot to one Kamlesh Saxena. So it's not the issue.
If you can consider it on humanitarian ground.
Well,
extra time on humanitarian grounds, we reconsider. Hey, Mara, we gave them.
Lordship, that is a different issue. That is a very different issue, ma'am. For me,
So she's saying 2021 husband died.
and 23, they have allotted
When,
somebody else,
what is the date of your husband's death?
5th January 2021. So there is a death certificate, ma'am.
You take instructions. Yeah.
Yes.
4 weeks time is granted to the learned counsel for the DDA. Right, we issue notice. Srimati Tripathi will notice on behalf of the respondent. Put it after 4 weeks. Yes. Okay, 6 weeks. Hey, we are inclined, we are inclined to issue notice in the particular facts since the petitioner's husband was allotted the original plot has died in 2021, and on account of his death, the petitioner could not make, the applicant could not make the payment within a stipulated period. उसके बाद में we have recorded that.
Placed everything on record, Your Lordship. We have also.
They're only on that ground.
22.4 is concerning to the development of the Rohini area.
So that will be again going beyond the scope of the writ petition.
I was made these particular IA, that the MAs were filed by the petitioners in my SLP. That is why I am here.
But now your SLP is itself disposed of.
SLP, but it was given the liberty to file the concerning the issues in this particular SLP.
Only for interim orders.
Interim order. Now, this interim order, these petitioners issued raised the issue of the development of a kacha, the outfall drain in that area, and they were क्योंकि उनको लग रहा था कि ये जो अगर यहाँ बनेगा ये जो कच्चा ये ड्रेन तो उनकी जो प्रॉपर्टी है दैट विल बी इन प्रॉपर उसमें काफी डायरेक्शन यहाँ से हुए और उसमें एक जो एसएलपी मेरी जो कंटेम्प्ट पिटीशन जो था वो भी डिस्पोज ऑफ हुआ था ऑन द बेसिस ऑफ देयर एफिडेविट दैट they are making a outfall drain in that area.
We are not inclined to entertain the prayer made in the I in a dispose of petition.
No, but
the applicant would be at liberty to take such steps as are permissible in law. Next point. We can't open a Pandora's box in a dispose of petition.
Sir, I'm not the party in this particular case. I have not filed these NAs. These NAs were kept pending by this honorable
Okay,
court.
now we are disposing it off. Thank you. Yes, next matter.
SLP has been filed against the order of the HET. I just give my lord in 1 minute what the background is. My lord's various constructions were made because at that time the authority was not available for environmental clearance. Notification thereafter came to be issued by the MOEF saying that these buildings which had started, they can be given clearance if they are in accordance with law otherwise, and they will not be penalized for what had having started work. That notification came up before the NGT, which quashed the notification and said that is and held it was ultra-virus. My lord, at that order, please see at page 237. 237. After quashing it, the NGT said
applied for your environmental clearance, however held, your lordships will see it starts at page 235, 163. We pass the following order and directions. We hold and declare that the office memoranda are ultra vires the provision of the Act notification, suffer from infirmity, etc. My lords, kindly see, this was for builders across the country. Consequently, above office memoranda held to be ineffective, we prohibit MOEF and SEIAA in the entire country from giving effect to these office memoranda. Hold and declare that resolutions passed by the SEIAA delisting the applications do not suffer from legal infirmity, and then a committee is formed. What is important is paragraph 10 at page 237. All the project proponents shall pay environmental compensation of 5% of their project value for restoration and restitution of the environment and ecology, as well as towards their liability arising from impacts of the illegal and unauthorized constructions carried out by them. They shall deposit this amount at the first instance, which shall be subject to further adjustment. Liability of each of the respondent is as follows. My lords, we are item numbers 2 at page 238 and the second last, Dugar Housing, which is also at page 238. So at the first instance, we were told to do this, subject to further adjustment. It thereafter went before the SEAC. My lords, where, and the environmental clearance, where it was held that the environmental damage was in one case 29 lakhs, in the other case 54 lakhs, 33 and 56 in my cases. My lords, I therefore file an IA for return of the balance deposited money because this was at the first instance. Unless they say, no, you may have got permission you may have got permission for an environmental clearance. They may have assessed the environmental damages but since we told you 5 crores, it's 5%, it's 5% plus that. I came up before your lordship's court against that order, and my lords are pleased to pass the order at page 525. At page 525, starting at page 527, at 526, my lords have allowed my appeals in the terms of this order at 527. The challenge in these appeals, have my lords got that? 527, my lords.
Yes.
The challenge in these appeals are to the orders passed by the NGT, New Delhi, etc., within which the applications made by the appellants for refund of the compensation came to be rejected. We have heard counsel for the appellant and counsel for the respondents. A number of original applications came to be filed before the learned NGT, challenging the office memorandum so-and-so issued by Ministry of Environment, Forest and Climate Change in furtherance of the notification issued by the state of Tamil Nadu, dated 14 September, titled Environmental Clearance Regulation. Learned NGT by a detailed order has set aside the office memorandums. Within the same order, Learned NGT also constituted a committee for ensuring compliance with the resolution orders passed by the SEIA and passed under directions in the said order. Committee was required to inspect all the projects in question, submitted a comprehensive report. We did subparagraph 10 of paragraph 163 of the impugned order. All the project proponents were required to pay environmental compensation of 5% of their project value. Said subparagraph, NGT had also specified the amount to be paid by each of the project proponents. It was also provided said amount was to be deposited at the first instance, which would be subject to further adjustment. Insofar as the present appellant is concerned, liability was earmarked at 7 crores for the appellant and so-and-so liability of 6 crores. The said order was challenged before this court. Though notice was issued, subsequently petitions were withdrawn with liberty to the parties to adjudicate their grievances before the appropriate forum. Pursuance of the orders passed by the learned NGT, the SEAC considered the inspection reports, ecological damage, project plan, compliance, found that the appellants were liable to pay corporate environmental at 2% of the project cost. This is important, my lord. That was the holding there. It is the contention of appellant that the amount deposited by him was much higher, that is 5%, whereas assessment by the SEAC was only 2%. As such, the appellant was entitled to a refund of the excess amount. Counsel further submitted that insofar as the other project proponents are concerned, though they too were directed to deposit 5% of the amount by the NGT, they deposited a lesser amount, which was thereafter adjusted by the SEAC in the calculation of corporate. He therefore submits a discrimination. My lords, those who deposited a lesser amount, they were not asked to deposit more. I had complied with the order, pursuant to your lordship's order, so I'm not getting a refund. Council further submits that now that the environmental clearance are required, as required under the Environment Protection Act has already been issued, and the possession of the tenements is handed over to the allottees, appellants are entitled to refund. Additional Advocate General appearing on behalf of the respondent state submits that the assessment of 5% by learned NGT was independent of the assessment of the SEAC, and therefore appellants are not entitled to refund. He submits that
what is the
25%.
meaning of the adjustment there? Why mention adjustment in that order?
Exactly. That's why your lordship said paragraph 11, page 530, prima facie, we do not find any merit in the contention of learned counsel. Subparagraph 10 of paragraph 163 of the impugned order specifies the amount on ad hoc basis of 5%, further clarifies the said deposit would be at the first instance, same shall be subject to further adjustment. In any case, when a specific contention to that effect was made, NGT was expected to consider this aspect. However, by a non-reasoned order, learned NGT has rejected the claim. That view of the matter, we are inclined to allow these appeals. Impugned orders are quashed, set aside. Matters are remitted back to NGT to consider the applications of the appellants. Now, the strange thing is, my lords, the SEAC's order, in my case, says this is in addition to the 5% you shall pay this ecological. They assess ecological damage at that, and then say this is in addition to 5%. In somebody else's case, they say it will be adjusted out of the 5%. I bring that also to my lord's notice. Now, please just see the impugned order, my lords. Impugned order is a complete restatement of the first order. The impugned order, my lords, will kindly see at page 2. My lord extracts fully the earlier NGT order. Before that, my lords, kindly see 2 is a first line. Tribunal also constituted joint committee to ascertain the extent of violation of norms by the housing projects. Also directed project promoters to pay environmental compensation at the rate of 5% of the project value for restoration of the environment. Now it's been found that for restoration, the amount they assessed was 2%. Now your lordship will see thereafter the entire order is extracted. Paragraph 3 at page 4. My lords will kindly see the first order of the Supreme Court, where we had come at the very first instance against that order, and your lordship said, no, go back to NGT and argue it. Paragraph 4 at page 4. Thereafter, PP was granted EC dated 10/8/18, subject to certain conditions, including deposit of 2% of the project cost towards corporate environment responsibility. Then your lordship will kindly see paragraph 5. The earlier order of your lordship's court at page 5 is extracted. What I just read to my lords. Now your lordships will see the finding of the NGT. We have heard counsel, paragraph 6, who submitted in terms of subpara 10, the deposit was subject to further adjustment. In light of EC conditions fixing liability of 2%, excess amount is liable to be refunded. Though the argument appears to be prima facie attractive, we are unable to accept the same for reasons that follow. No doubt, the amount to be deposited under subpara 10 of para 163 was subject to further adjustment. Such adjustment was to depend upon the report of the expert committee about the extent of violations as shown by paras 12 and 13. Subpara 11 further shows that the amount to be paid also covered liability for intentional default conduct of PP and was to be utilized by the state PCB subject to further orders. Learned counsel of the applicant is unable to show any report of the committee which may call for refund. Well, they constitute a committee, then my damage is there. How can I be levied a penalty without any reasoning? At the very worst case, they should have then said, why should it be 5%? Only material referred to is lesser amount as condition for grant of EC, which is not shown in any manner to be compensation for violating or going ahead with the project without requisite EC. In view of, I did it because of the MOEF notification, which was quashed. Further in
we have to see the committee report, how they quantify the penalty.
Committee report goes on the basis of 5% as ordered. That is my bigger grievance. All right, my lords, let me say that what the EC had said, what the SEAC had gone on the actual damage. Let us say it is to be said, no, it's not actual damage, pay something more. I should be given a hearing, an opportunity, something. The earlier was an ad hoc payment. How can the ad hoc payment be treated as a final payment?
Where is that finding? Committee?
Well, the ad hoc I just showed your lordship that time.
Ad hoc you showed, finding that.
I'm reading it. I'm reading it now. But further in view of the law laid down in so and so, etc., the compensation amount covers deemed damage to the environment by going ahead with the project with prior appraisal of environment impact as required for grant of EC. Some of the observations from the same judgments are as follows. My lords, these are then taken. Paragraph 8. In the present case, EC order dated 10/8/18 is as follows. The CR amount, that is, my lord's compensation for environmental restoration, shall not be claimed at any point of time from the environmental compensation of 1.5 crores remitted so and so as per the order. The CEs, that's why I went to the NGT and says CAC says this is your environmental damage, but since the NGT had directed you to pay that amount, we can't direct you to get a refund of that amount. New Delhi order as committed in the affidavit submitted by the proponent, TNPCB shall utilize amount of 23 lakhs. That is the amount. Earmark the CR for governmental activities, projects for the following purposes. This is what the money was to be paid for. So far as any restoration is concerned, I have to pay for that and I paid for it. And they've also filed an affidavit here that I've done all the restoration that needs to be done. Water conservation still. So this is what the 2% has been levied for. Water conservation, stormwater management, urban greening, etc. EC conditions cannot override determination by the tribunal nor the ground for tribunal to revisit its order. Only other argument. So, my lords, they take the earlier order as the ad hoc payment of 5% as a final order.
No, where is it referred in the EC order about earlier order also being added?
My lord, that's there, my lords. I'll just show you, lordship, in a minute. It quantifies the damage as 23 lakhs, but says I'm not ordering adjustment of the 23 lakhs out of the amount paid by you because that was pursuant to an NGT order. That's why I go to NGT.
No, CR amount of 23 shall not be claimed at any point of time
from the
compensation of 1.50.
That was the 5%.
No, you paid 6.50.
1.5 and then it was stayed by your lordship's order. Other case I paid 4.5 crores. Your lordship stayed the order after I paid that first 1.5 crores.
It is part of 5% that was deposited.
1.5%.
1.5 was only part of 5%.
Absolutely. My learned friend is right.
But so, still the compensation assessed is only 23 lakhs.
23 lakhs. And what the SCAC says is, the ministry says is, since NGT directed you to deposit that money, you can't claim this 23 lakhs, which is your compensation out of that. Now, my lords, two things happen. One, expenses for restoration I have to undertake. This 23 lakhs, your lordship will see what it is utilized for.
Even this para 27 can only mean that you independently deposit 23.59 and take back the 1.50.
That is to be done with the NGT. Now, what is more important, my lord, this 23.59 lakhs was not for any environmental restoration. The NGT says, what is for environmental restoration is one thing, otherwise we have to punish you to make you pay for the environment and therefore we are charging more. That's what this order goes on. But if your lordship sees that TNPCB shall utilize the amount of 23 lakhs, which I am now paying as earmarked as CR for governmental projects for the following purposes: water conservation, stormwater management, urban generating, biodiversity. So I am paying for that. Manoj, apart from that, there's no environmental damage. So and my BG has also been returned because all that has been done. Now, my lords, kindly see, the finding is EC condition cannot override determination by the tribunal. I asked myself, where was the determination? You say 5 crores to be paid ad hoc, subject to decision later.
But insofar as your the challenge regarding discrimination is concerned, the learned tribunal record that those orders were recalled.
No. I'm coming to para 10. Only other argument for the applicant is that in another case.
No. In para 10,
yes,
it is also mentioned by the applicant itself that the said order of TN was later withdrawn.
That's completely wrong. That's completely wrong.
Is it a matter of fact?
No, I've stated so, my lords. I filed the order.
There is nothing in the appeal, they say.
I filed that order. The order has not been withdrawn in another case.
Appeal, they do not challenge this paragraph.
My lords, he can be fair and tell my lord, has it been
Whether,
withdrawn or not?
whether in case of other PPs, whether the amount has been adjusted.
But my instruction, there is nothing, no such kind of thing.
He has made a specific condition,
Yes.
which is recorded by our earlier order,
Yes.
sitting with Justice Narasimha,
Yes.
that insofar as other persons are concerned, though they had paid a lesser amount, that has been adjusted.
My lord, I remember.
So merely because he has abided by the orders of the NGT and paid 5%, he has been denied that adjustment. That is what his specific contention is.
My lord, the order is at page 392.
I'll take
In the other
instruction on this
other
appeal.
party's case, the order is at 392.
That is
No,
specifically.
because in this appeal, they have not challenged this para
No,
10.
the order is there.
Para 10.
No, Mr. Tiwari, even if you read para 10,
Yes, my lord.
it can only mean, subject to what you say,
Yes, my lord.
those parties also, they were given a facility of adjustment with the compensation. Suppose they had deposited 1 crore
Yes,
and the compensation is 20 lakhs.
Yes.
Like he was told, you have to independently pay and not adjust.
Yes.
Perhaps some facility was given saying we will adjust it with that amount, but that has been recalled.
yes.
How does that detract the refund of money in his case or the balance in their case?
My lord, I'll make good, my lord, because I'll sustain this order. How this order is good, I'll in my turn, my learned friend finish, on this aspect, my lord, we'll get back.
My lord, may I just show your
Not
lordship
likely to
page
finish today. By
392?
tomorrow morning, we'll be back with this.
My lords, can I just take one more? Part of this SLP is that very order. That's very much a part of this SLP. Please see page 392. That order's been with, they have never said anywhere here that this order does not stand. It starts at page 366. In the case of another party, 366. And kindly turn to page 392. At 391 it starts. For that party. The committee observes that the project of Mrs. SPR, that's the other party. Page 316, 391. The order starts at 366. We're dealing with a number of companies. 391. The committee observes that the project of SPR, a construction, etc., comes under high-level ecological damage, amount prescribed for ecological remediation, natural resource augmentation, community source, etc., same as mine, totaling 251 crore, 2.5, shall be remitted in the form of bank guarantee to the Tamil Nadu Pollution Control Board before obtaining environmental clearance. Now, 2, the amount specified for CR activities is rupees 2.51 crores. Deponent has paid 1.5 crores to TNPCB out of 12.5 crores levied by the Honorable NGT. That party out of 12.5 paid only 1.5. The Environmental Compensation Fund of 1.5 crores already is permitted to be adjusted against the 2.51 crores to be paid, thus leaving a balance of 1.01 crores for the net amount to be paid. For 1.01 crores, the amount shall be remitted in the form of a... This order is part of this SLP. Nowhere in the counter they deny this. This order has been pleaded at page 26, 25 of my SLP. Just 1 minute. Page 25 of my SLP, my learned friend said, where have I taken this? Page 25. Okay, I don't have... My learned friend says, you
Mr. Tiwari, you are the additional advocate general. Don't be so hyper technical. That para 10 is not.
If they were asking for the whole amount, the direction will be not 1.01. It will be 11.01, balance of...
Yes. 7 minutes, tomorrow morning, I'll seek instruction.
You take instructions on this, only on discrimination part. If you have given an equal treatment to everyone, then it's a different matter. But somebody does not abide by the condition, he pays less, and then that amount is directed to be adjusted in a larger amount. He pays larger, but he is not permitted to be withdrawn whatever he has paid in excess.
also not paid the full amount.
That is what he says, he has paid in, he has paid
1.5
full amount.
crores in one case and 4.5 crores in the other case. My total is only 22 lakhs. In one case, and it is put in, I should get a refund.
5% would be, in one case it will be 7 crores, in another case it will be 5 crores.
whatever it be, but then
But on factual aspect, I'll
the
come
committee
back.
itself has determined 22 lakhs and 27 lakhs.
That aspect, I'll come back to that.
My lord, can I show your lordship?
One second, you just see para 2, which is just read.
Yes, ma'am. The amount is specified in CR activity.
2.51 is what they arrive at.
Yes,
The
Lord.
original order as per NGT's interim is 12.5.
Yes, Lord.
He has paid 1.5.
Yes,
So
Lord.
there was a balance of 11.
Yes, Lord.
Correct.
10 crore rupees. 11.
11.
11.
Now, if further 1.01 is to be only ordered,
Yes.
if NGT is also to be paid, the order will be 12.01.
Yes, Lord.
They asked only for 1.01.
CR is a different component than the environmental damage as has been imposed by the learned tribunal, Lord. That is what the aspect which is being considered in this appeal. The question is whether environmental damage.
So did they realize the balance 11 from this party?
Yes, Lord.
If they have not, he has to get the balance between 23 and what he has paid.
Yes, Lord. I'll seek instruction on this. This aspect I'll clarify, my Lord.
Madam, this very aspect has
But
been
here
taken
the
up by
question-
us at page 25,
But-
paragraph
but
2.16.
here the
My
question-
learned friend says we didn't take this up in the SLP, page 25, paragraph
Here the
2.16.
question is that whether this CR, because this CR, my Lord, is akin to CSR. It's a corporate environmental responsibility, and therefore it has nothing to do with the environmental damage caused by the project proponent, which is the 5% cost imposed by the NGT for carrying out a project in violation of the, either in absence of a clearance or in violation of clearance term.
Then
So
there
that
has
is-
to, then there has to be determination.
Yes, Lord, that is what determination has been done by
Not
the
amount,
order.
that there is a damage, this is the apportionment.
Lord, what has
You can't
happened
have
that
it both ways, the
No,
23.
I am not having both this. Lord, kindly have a para 7 of the order, Lord. Para 8 of the June order, if my Lord may kindly have. There are 3 reasons given by the Honorable Court, my Lord, which starts at page 6, para 7. The first reason is given that the committee does not say that no damage has been caused by this project. There is an assessment of damage being caused by this project. So there is a first, that's the first.
How much is that?
Well, that assessment has been made that they have carried out in violation of the EC. And therefore, there is I'll show from there how much the remedial, so there will be 3 components which could be looked into in this case. One is that corporate environmental responsibility 2%, which is akin to the 2% CSR responsibility. It is something like that you impose 2% on every project, considering what kind of damage the project imprint it would leave on the environment. That's one aspect. The second part is the remedial measure for the damages which is caused. For that, there will be an assessment, which assessment has been done in this case by the EC, the committee.
22 lakhs.
42 lakh and some other lakh.
So then?
And third is the environmental compensation, which is imposed by the tribunal under section 15 for carrying out a project in violation or without having a valid EC for carrying out such project. So there are 3 components. Today, my learned friend is mixing the third component with the first 2 components. The learned tribunal has clarified this position in this impugned order, that my third component, which is 5% of environmental compensation, is an independent determination under section 15, keeping in mind the consistent penalty which is being imposed by this honorable court, the honorable Supreme Court, in a large number of judgments, starting from Goel Ganga. And that is what my learned friend has not read that portion.
Only discrimination we have to see.
So
Satisfy us on the point of discrimination.
discrimination, but I'll see.
That and one other aspect I want to point out.
Yes.
There is no determination of 5%. They said at the first instance, subject to adjustment. My learned friend wants to make that the penalty. Surely to enforce penalty, there has to be a reasoning process and a penalty has to be imposed.
Goyal Ganga, what Goyal Ganga says, my lord, Goyal Ganga has been quoted in detail in the other matter 23.1, my lord, the Jones file, if my lord may kindly have. That impugned order quotes the.
No, that's also quoted here. Page
Here,
seven,
but
it's the
here
same.
3 sentences quoted. I want to show that why Goyal Ganga is quoted at page 8 of that other judgment, my lord. And here the court, the Honorable Supreme Court says, my lord, in the consistently they are levying 5% penalty, and in some cases more than 5% for carrying out a project without EC.
Some modifications in the IA.
Yes, but there are all.
I have appeared in that, let's be honest.
But there may be some modification.
You point out the aspect regarding discrimination.
Next year.
You said
But there seems to be, there is a change in the office setup and the flood, because of which he is saying some, yes, flood there, it is flooded. Flood
in
there.
Tamil Nadu?
Tamil Nadu, it's badly flooded.
In the counter, they do not say this at all. My learned friend is making an exhibit saying, I have, my lord, specifically pleaded this point both as my question of law and in page 25.
Next week.
Tuesday.
Next Tuesday.
I apologize for not having.
Beg your pardon?
I say I apologize, I should have been ready on this aspect.
You are on only paragraph 10 not challenged.
Would your lordship have it as butter so it'll come on top? That's all I request, madam, because it's butter. I'm very grateful.
Short point about application of the new land act for laying out guidelines. We are yet to receive publication.
Next Tuesday. Yes.
Yes,
We can hear only one at a time.
Sorry. My lord, can I request your lordship?
Mr. Paranjabi was saying something and you intercepted Mr. Kaushik.
Not my matter. Could you have next Wednesday instead of Tuesday, my lord? Next Wednesday instead of Tuesday.
Tuesday has to go on Tuesday.
Oh, Tuesday.
Item 44. Item 44.
Yes, Mr. Paranjabi, high on board next week.
Yes, it will. Item 40.
Respect to the extrajudicial killings which had been carried out in Assam, item 29. Your lordships had given a short 2 weeks for a report to be filed by the union. I'm seeking your lordship may keep it on a short date, your lordships.
Item 44, my lord.
Vacation के बाद
Item 44, item 44, my lord, item 44. Morning it was taken up, but